SJC-13354, maybe Doucet and others, v. FCA US, LLC, and others.
Trying to wait for things to settle down a little bit before you get started. No, you can stay up there. Whenever you're ready, Attorney Gupta.
Should I wait for Justice?
He's
No,
recused.
he's recused.
Oh, I'm sorry, I didn't know that.
No,
Okay.
but that's kind of you.
Thank you, Chief Justice and Associate Justices, and may it please the Court, Deepak Gupta for the Plaintiff Appellant, Paul Doucet. When a corporation sells a product to the public in the Commonwealth, and that very product causes personal injury, the Commonwealth courts have the power to entertain a suit against that corporation. That is true regardless of whether the injury is felt out of state, and nothing in Ford overturns that settled rule.
Where is that rule settled?
That rule is settled, I think, because of this court's longstanding rule that but-for causation satisfies the relatedness requirement for specific jurisdiction. So in Tatro, this court held that where the transaction in Massachusetts is the first step in a train of events that results in injury, that there is specific jurisdiction. And the court further recognized that that is true, that but-for connection does not disappear when the plaintiff is injured in another state. And so I think what the Superior Court should have done is simply applied this court's longstanding precedent. Contrary to what the Superior Court thought, Ford overturned none of this. Ford's central holding was that a strictly causal relationship is not necessary. But Ford did not reverse the prevailing understanding or this court's precedent holding that but-for causation is sufficient. So both as a statutory and a constitutional matter, specific jurisdiction over Chrysler and its successor is proper in Massachusetts because of the sale of the car in Massachusetts, which was the but-for cause of the plaintiff's injuries. That Massachusetts sale, as this court has put it, was the first step in a train of events that resulted in injury.
Just so you go. So from what I understand, Chrysler distributed the car to Rhode Island, right? Not to Massachusetts, right?
No, the first sale to the public was in Massachusetts. It is true that the car was shipped into Massachusetts from Rhode Island, and that's not uncommon when cars are sold. They're often, I remember buying a car, and they don't have the blue car at the dealership, and so they send it from another dealership. But what matters for purposes of personal jurisdiction is when the product enters the stream of commerce, when the car is sold to the public. And car companies don't sell, with the exception of maybe Tesla, they don't sell cars directly to consumers. They usually use their authorized dealerships. Here, an authorized Massachusetts Chrysler dealer sold the car in Massachusetts to the public. And so it's that action by Chrysler through its dealership network that means that Chrysler purposely availed itself of the privilege of doing business in Massachusetts. And with that privilege comes the reciprocal obligation to face suit in Massachusetts when that product injures someone. And the Supreme Court recognized that as long ago as—
Is there any state that Chrysler would not be subject to personal jurisdiction in, under your theory? They've made a car and now it's ended up in, I don't know, we shipped it to California, but there, somebody in Massachusetts wants that purple car that's only in California.
Oh, no, I want to be really clear that the theory we're urging here is quite modest. The theory here is just under this court's existing precedent, where there is a but-for causal relationship, in other words, where the car is actually sold in Massachusetts, Massachusetts is a proper forum. It does not mean that the Doucets would be able to sue Chrysler anywhere else in the country.
So you're arguing sort of the opposite, or you're actually arguing Ford's position in that Ford case.
Well, it's
The
not
place
quite- no,
place of first sale
It is-
is the place or a place of
It's
personal
a place, and I
jurisdiction.
think that's the big difference here, and I think this is how the Superior Court got confused. I'm not arguing Ford's position in Ford. I represented the plaintiffs in Ford, so I'm not arguing anything inconsistent. In Ford, what Ford was arguing is that a strictly causal relationship is necessary, and that no other kind of relationship can satisfy specific jurisdiction. But Ford and everyone in Ford in that case understood that a strictly causal relationship would be sufficient. And nothing in the Supreme Court's decision undercuts that settled understanding or this court's precedent recognizing as much. And so it's been settled since at least Worldwide Volkswagen that when a car company, through its distribution network, sells a car in the forum, that there's personal jurisdiction. As the Supreme Court said in Worldwide Volkswagen, the
But
forums...
in that case, wasn't the accident also in state?
So the facts, I'm not relying really on the fact pattern in Volkswagen. That was a much harder fact pattern. What happened is you had a couple that bought a car in New York through a Volkswagen dealer in New York, and then they drove to Oklahoma, and the accident was in Oklahoma. But nobody doubted that they would have been able to sue in New York. And that's what this lawsuit is, right? This lawsuit is if you take the facts of Worldwide Volkswagen, but the couple had sued the dealer from which they purchased the car in New York and Volkswagen and Audi in New York. So this is this much simpler case, and I think that's why, it hasn't reached the court. The Ford case was the harder case, in which the question was whether you go beyond a causal relationship, and the court said, yes, you can go beyond a causal relationship. The Superior Court made the mistake of looking at Ford and thinking that, well, these facts are different from Ford, and so somehow under Ford there isn't jurisdiction. That was just a pretty elementary error.
Well, but the sale here is really attenuated. The sale in Massachusetts is really attenuated from the accident, right? I mean, the sale takes place what year?
It's 2003.
So they send the car to Rhode Island. The Massachusetts dealer requests a red car. It briefly arrives in Massachusetts. Then, how many years later are we talking about? It's
About 10 years later.
so 10 years later, an accident happens in New Hampshire. They never bought the car. They bought the car in New Hampshire, I take it, right?
Yes.
So it's, I understand the but-for. I'm a great but-for person, but
Yeah.
This is really super attenuated. And does the U.S. Supreme Court really want to, I mean, we're dealing with that inner federalism language, and we've got, there's cause for concern here that we're going to get the U.S. Supreme Court lecturing us that we're not listening to them.
No, I don't think so at all, and let me try to alleviate that concern. I appreciate the question, Justice Kafka, because I do think that's kind of what's behind the other side's argument, is this idea that, well, if you look at it from the perspective of the plaintiffs, these plaintiffs who got injured, what did they do in Massachusetts? And that's exactly the wrong perspective. What the Supreme Court has said over and over and over again is that the focus is on the defendant's contacts with the forum. Why?
Back to Justice Wendland's point, I mean, Chrysler's a big company. They're dealing with every state in the union. They're sending a lot of cars into every
Right.
state. I mean, literally thousands and thousands
Right.
over years.
Well,
But
it might help you to think about a different kind of company. So imagine a company that isn't operating in all 50 states. Imagine a company that only sells products in Massachusetts, and this is why it matters. What matters is if you sell the product in Massachusetts, you're availing yourself of the privileges of doing business in Massachusetts, and there are obligations that come with that. And so the rule that we're urging would apply in that scenario as well. And in that scenario, the Doucets or someone like them wouldn't be able to sue in their home jurisdiction because there wouldn't be jurisdiction on a Ford-type theory available to them. They also wouldn't be able to sue the local retailer or dealer as they're doing here. And so I understand if you look at a company like Ford, you might think, well, why does it matter? The Doucets were, they did actually sue in New Hampshire, but
the U.S. Supreme Court seems to be providing certain kinds of limitations here, even for big companies. I mean, I haven't gone through all these different U.S. Supreme Court cases, but there's sort of some surprises where you don't have jurisdiction, right?
Well,
And he's
no, I
gonna
mean,
stand up and.
I have gone through all the cases, and I can tell you there isn't a case in the U.S. Supreme Court, or that I'm aware of from any state or federal circuit, for that matter, that forecloses jurisdiction against a corporation that purposefully avails itself in the forum and sells a product in the forum and is sued for injury caused by that product. And you may want to ask my friend when he gets up whether he's aware of such a case. The Ford case was a case in which everyone assumed that jurisdiction would be available at the site of sale. Ford's argument was, we grant you, under settled jurisdictional precedent, you can sue us where we've done something, where we designed the car, where we made it, where we have our headquarters, where we sold it. But in Ford, the plaintiffs were suing in the place where they lived and where they were injured, but where Ford argued it hadn't done
That
anything.
Ford is not, because they were saying arising from or related to, right?
Right.
Here it's arising from the
Exactly.
first sale. And
Exactly.
So I understand the point. So my question to you is, what is that case where the first sale is in the forum and nothing else is? Right? Like it is here, right? The Doucets live in New Hampshire. The accident happened in New Hampshire. They bought the car in New Hampshire. The only thing tying
Right.
to the Commonwealth is that first sale. What is that case?
So first of all, I would say, and I started to say this earlier, but there was a question, I just want to emphasize, what the Supreme Court has said over and over again is what matters is the defendant's relationship to the forum, the defendant's contact. So Walden versus Fiore is, I think, a case you should look at. That's a case where the plaintiffs said,
Case again?
Walden versus Fiore. And that was a case where the plaintiffs made the kind of argument, Justice Wetland, that I think you're talking about. They said, look, everything about this case, we live in Nevada, the injury is felt in Nevada, we should be able to sue in Nevada. And what the Supreme Court said is, no, the only thing that matters for personal jurisdiction jurisprudence is the defendant's contacts with the forum, and the defendant's contacts were with Georgia. And what that case stands for, and Ford interprets that case, what Ford says about Walden is that the place of the plaintiff's injury and residence cannot create a defendant's contact with the forum. So I understand if you're just in a kind of common sense way, in the kind of way you might think about for forum nonconvenience or choice of law, you might say, oh, well, the locus of the controversy, is outside the forum. But what's relevant here is, what did Ford do in the forum to avail itself of the privilege of doing business in the forum such that it would be fair and consistent with due process for them to expect that they would be hailed into
Focus on
court?
Chrysler's actions in the forum. They had the first sale in the forum.
Right.
What else?
Well, they have a network of dealers. They have 43 dealers in the forum. They advertise in the forum.
Is that in the record?
The record is sparse, I admit, but the record does. It is alleged that they have authorized dealers in Massachusetts, and they sold the car through an authorized dealer. That is more than enough for purposeful availment. And I think common sense tells you that you have the kind of purposeful availment that you had in the Ford case. It's a national car company. It's not a hard question when it comes to purposeful availment. So then the only question is are those contacts with Massachusetts, setting up a dealer distribution network, selling cars here, are those enough that when that product injures someone, that the corporation could have expected that it would be sued in Massachusetts? And I think it's notable that Chrysler, at least in their briefing, they can correct me if I'm wrong when they get up, they're not really arguing, I think, that it would be unfair for them to be hailed into court in this jurisdiction where they sold products, right? So if due process and the personal jurisdiction jurisprudence are about fairness and federalism, there either has to be some kind of fairness problem, which hasn't been identified.
But I'm still nervous about the U.S. Supreme Court. And Malden, I read Malden the last time, but I haven't read it recently. It's not one of those sale cases, right?
That's right.
Can you just, the question that Justice Wendell asked, which I really would like an answer to.
Sure.
Is are there cases where the first sale occurs, but then there's just nothing after that? Can you point us a couple of cases like that? Because
Yeah.
we are in this we're going right into what the U.S. Supreme Court was kind of vague about. And it would be nice to have some comfort. We're not going to get, the facial disgraceful, when
Yeah.
issue this your way if we do so.
I just, it's hard to understand how the U.S. Supreme Court could have any problem with asserting jurisdiction here when there's no argument that the defendant's contacts, which are all that's relevant.
Again, can you give me a
so-
couple of any U.S. Supreme Court cases or any Federal Circuit cases like this where there's a sale, but then nothing
Right.
connected to the forum for 10 years? Because I
I
just,
don't know that I can give you exactly 10 years, but what I tried to do in our 16L letter is to provide you with every case we were able to find post-Ford in which this issue has come up, where the argument was, the sale occurred or the transaction occurred in the forum, but there was an injury felt elsewhere, and the plaintiffs relied on but-for causation. And what those authorities show is that every jurisdiction we've been able to find recognizes that but-for causation remains the rule just as it was before Ford. Nothing in Ford undercuts that. So I'm sorry I can't give you a case that has this exact fact pattern, but I think it's also notable that there isn't a case that forecloses jurisdiction with this exact fact pattern. And so, if
it would have been nice if in Ford, the U.S. Supreme Court said, oh, of course you have jurisdiction this way and this way. Instead, they spend a huge amount of time saying that jurisdiction is appropriate where the injury occurs and kind of minimizing by comparison the opposite.
Well-
That's what gives me pause here, that we're running into a problem.
I can say, as the lawyer who argued for Ford for the plaintiffs, I think we all just assumed that the lower courts had, causation-based jurisdiction as a given, and so the question there was, is there also something else? And I think, and this is why we sent in the 16L letter, to give you some comfort that every court that we can find that has looked at this question has recognized that Ford doesn't undercut causation as a basis for jurisdiction.
So,
Thank
so tell me why the claims arise from that first sale? Is that because of Tatro and the chain of events?
Yeah, and just in really common sense terms, what's being sued about is Chrysler's
Design defect.
design defect. They made this thing, they sold this thing, they introduced it into the public, and yeah, it may end up elsewhere, but the place where they sold it was Massachusetts. And a defendant has an ability, this was a big feature of the Ford
And
case.
so the design defect claims arise from the defendant's first sale, an introduction into the marketplace.
Introduction into the marketplace of a product that's alleged to be defective. And the defendants have the ability to structure their conduct to face certain jurisdictional consequences. So they can decide where they sell things. One example that was discussed in the Ford case at oral argument was, imagine a company that wants to sell convertibles that are for warm weather, so they only sell them in certain states, and they don't sell them in other states that have cold weather. Well, in that case, the logical place to sue them would be the place where they sold it and where they, where they could expect to face suit. So this should be the easy case. This is the heartland case for personal jurisdiction. And Ford was, the more, the harder case, the more expansive case. But in expanding the scope of jurisdiction, the Supreme Court should not be understood to have sort of accidentally limited it. Thank you.
Very much. Attorney Durney.
Good morning, Your Honors. Peter Durney, on behalf of the appellee, FCA US LLC. May it please the Court. In discussing personal jurisdiction, we could debate the meaning of some of these extracted phrases that have come from various Supreme Court cases over the past 75 years since International Shoe. We could also take a look at, in the Ford case, the multiple references to informed plaintiffs, resident plaintiffs, informed injury, and
Isn't your opposing counsel correct that the focus is really on the defendant's conduct in forum? And so,
I would say
the
that that's
fact that they designed a car in Michigan and then had the first sale in in the Commonwealth is the focus, whereas where the Doucets ended up getting injured by the car that was designed in Michigan and first sold in Massachusetts is neither here nor there.
Well, it's rather complicated when you look at it, Your Honor, because what I was hearing from counsel was sort of a purposeful availment argument that the companies come into Massachusetts and the company has a network of dealerships and they bring products in. But what the Supreme Court was looking at in the Ford case, of course, the arguments in the Ford case are a matter of public record, and I have listened to Mr. Gupta's very eloquent argument. They were, in fact, per your question earlier, arguing exactly the opposite of what they're arguing here. And, of course, Ford changed the landscape in multiple ways, but there are questions in examples embedded in the Ford decision that are very important. Because if you look at, for example, the discussion about the arises from or relates to, the court is very clear to say this does not mean anything goes in the concurring opinions that was picked up on. And anyway, the court goes on to say in the sphere of specific jurisdiction, the phrase relate to, which is the second part, incorporates real limits. It must adequately protect defendants foreign to the forum. Put differently in the Ford case, they're very specific, and I think this is to your question.
You mumbled something after incorporates real limits. I didn't hear what.
Incorporates real limits, I beg your pardon, Your Honor, as it must adequately protect defendants foreign to a forum. And so those are that's really the rules derive from, according to the Ford case, and reflect two sets of values, and that's a direct quote.
I get that.
Okay.
But then the way this was phrased at the very end, maybe it was by Justice Wendland, a defective product has been sold to us in Massachusetts. Is that enough to say this is not it's not a defendant foreign to the forum? Because in its most basic sense, you sent a defective product here for sale. But I think that it's a question, not an answer. You know, is that
I understand, Your Honor.
Yeah.
No, I think that the defendant is definitely foreign to the forum because under the Bauman case, they are at home in the place where they're incorporated or the place.
But we're not talking about general jurisdiction.
I
This is
understand.
specific jurisdiction.
Right.
So let's just stick with that.
But I think that just makes them foreign, is all I'm saying. They are foreign to the jurisdiction, and the plaintiff is not alleging general jurisdiction here.
Yeah, but they purposely availed themselves of Massachusetts by making their first sale in Massachusetts.
There's no argument, I think, in this case about the purposeful availment component or in the reasonableness section of the three-pronged test.
Right.
The relatedness test is what is really at issue.
But that's an either or, right? It's either arising from or related. And the Ford case
Correct.
was about that or related. So let's set that aside and deal with arising from.
The-
And under Tatro, isn't your opposing counsel correct that we have interpreted arising from to the extent of the Constitution, meaning but for, not proximate cause, but for?
I don't disagree with that insofar as it relates to 233A3A, the long-arm statute. I think we're talking about the arising from language in the long-arm statute, and I think that's where some confusion may arise. In addition to that, the Tatro plaintiff was also a Massachusetts resident, as you recall. Now, she fell in a bathtub in California, and she had made the arrangements for the California hotel through the internet or through these various discussions with people. And then there was a long discussion about the fact that the company had contacts with Massachusetts where they directly billed clients and the like. But to answer a question that came up earlier, I am unaware of any case that would say that a sale of a car in Massachusetts or any other state, first sale, to a non-plaintiff or to someone who does not
Reside in the
reside in
forum.
the state, not injured in the state, et cetera, gives the local court in that form the basis for jurisdiction. Now, there have been cases that have talked about, one of them was Choi that was cited. It's a California decision, came out after Ford. We actually put it into our brief in the addendum. The Choi case involved a gentleman who was sold a car, new presumably, in California by a Penske dealer in Cerrito, California. That vehicle was sold to Mr. Choi, who was ultimately injured, but he was out of state when he was injured, so they brought the claim in California. Now, the court in that case analyzed some of the discussion in the Ford case, and ultimately, in part because he was a resident, he bought the car in California, but also because they have privity in connection with warranty cases in California, that California was an appropriate forum. Now, that's the only case that I can think of that even comes close to this scenario, and this scenario is very different because, as we all know, Mr. Doucet was not a resident of Massachusetts. He was not injured in Massachusetts. He didn't buy the car in Massachusetts. And that's setting aside the nuances between the two companies because it was sold by an old car co, which is pre-bankruptcy, and then you have FCA US LLC down the road that's been sued. But I think it's interesting we need look no further than these two. There's a footnote 3 in the Ford decision. I'm sure you've seen it, but I'll address it if I may, if you can indulge me just for a second to read it. It says, in thus reiterating this court's longstanding approach, we reject Justice Gorsuch's concurrence is in brackets, apparent, if oblique, view that a state court should have jurisdiction over a nationwide corporation like Ford on any claim, no matter how unrelated to the state or Ford's activities there. They go on, they say, on that view, for example, a California court could hear a claim against Ford brought by an Ohio plaintiff based on an accident occurring in Ohio involving a car purchased in Ohio, removing the need for any connection between the case and the forum state would transfigure our specific jurisdiction standard as applied to corporations. Case-linked jurisdiction would then become not case-linked at all.
You read that quickly. In that hypothetical,
Yes,
is
sir.
the first sale in the forum or not?
It was
Or are all the things outside? Here we have,
purchased in Ohio.
Yeah, so it's different.
it's different.
Yeah, I don't know that they said it was the first sale or
I'm just,
a subsequent
yeah,
sale.
it's just,
But
I get that Justice Kagan is saying, okay, you can't, just because they're Ford doesn't mean you have jurisdiction anywhere, but you have this additional fact which is, again, the first sale of this allegedly defective car happens here. So, it's like the act that we're most worried about takes place in Massachusetts. Now, maybe there's nothing wrong with the car.
well,
But if it is a defective car, it's sold in Massachusetts to a Massachusetts resident, so we have concerns about that, right?
and I understand that, Your Honor. I think, but if I hearken back to the question that was asked earlier, can you sue a company like Chrysler in any state? Can you just?
So can these plaintiffs go anywhere?
Can they go anywhere in
I
the
mean,
United States?
if
No.
they can't go to New Hampshire and they can't go to Massachusetts, Michigan, is that where they go?
Are you asking Justice Seifert whether they have preserved their right to go into an alternative form, or whether originally they had an alternative
Whether there
form?
is an alternative for them?
Today.
Originally,
to
no,
answer-
originally.
Oh, originally, I think that, well, of course, the oddity about this case and the complexity of the case relates to, in part, the fact that Ford came out between the decision in New Hampshire and the decisions down here.
I mean, didn't you argue in New Hampshire, this is not the right forum, send us to Massachusetts?
Actually, that's we argued that it was not the correct form. We did not argue, as some people have posited in the amicus briefs, that there was an alternative forum and it was Massachusetts. We never said that. As a matter of fact, the court can look to the transcript of the hearing in New Hampshire. It begins at page 450, I think, of the transcript. Of the record appendix. And Judge LaPlante said,
So let's simplify this a second. If we rule for you,
yes,
does this terribly injured person have no forum at this point in time?
that's Your Honor, I knew that question was going to come up because as a matter of human
Decency.
decency and, of course, sympathy, that is a consideration. There are two things that I would say in response. If I can just...
I would just, is there a yes or no to
I don't
begin
know.
with?
I don't have a yes answer for that. I don't have a no answer for that because of a couple of different things.
So then,
One,
will that raise the issue of whether we're going to hold you to your original I mean, New Hampshire clearly now, after Ford, was an appropriate jurisdiction.
and they never appealed the case up there, so that they're left with this particular situation. But the problem, the judge asked if we would agree to a transfer to Massachusetts, Your Honor. And if you look at the end of the transcript, Chief Judge LaPlante said, okay, get together and see if you can come to an agreement about an alternative. There were two different clear paths that were available, Michigan and Delaware. And we were being asked about Massachusetts. And we reported back that we did not agree with Massachusetts. And yet the plaintiff thereafter, after the judge went ahead and ruled.
You can see why someone doesn't want to sue in Michigan.
That could be true.
Home of the automobile industry, home of Chrysler, a million miles from their home. I can see why they want to be somewhere else, right?
And I don't disagree with that, Your Honor, but what I would say, and to answer your question, I'm sorry, I didn't want to not answer it.
Having clerked on the Michigan Supreme Court, I have nothing but respect for Michigan, but I can see why they don't want to go there.
Well, to answer your question, though, was whether there's an alternative forum. And Michigan, as I understand it, does not have a savings statute. Delaware had a savings statute, but I think it's a year. But setting that aside for the moment, I think we really need to look at the considerations that drive the jurisdictional analysis, which are fairness to the foreign defendant, and then the considerations of federalism, which is emphasized in the Ford case. Now, I mean, I'm a human being like anybody else. I understand that people can be very seriously injured. As you pointed out, there may be nothing whatsoever wrong with the car. So it's not a given that there was a defect that caused the injury. But with all of those factors taken together, you can see why there would be some reaction to this being somewhat of an unfair outcome. But it's not. It is a consequence of the law as the law exists. And Justice Howe went through the analysis in a very careful way. I don't think that it is in any way out of sync with what this court would expect from one of its jurors. And I don't think that it is anything out of the ordinary or out of sync with the language that we've heard coming out of the Supreme Court of the United States. In fact, I think it comports exactly with the analysis that they would expect a jurist to go through. They're not saying it's open season, that you can go anywhere you want. And to get to the point about whether you can sue anywhere, which Justice Seifert was asking also, I think, I hearken back to there's a quote from the case, the Worldwide Volkswagen case, where they talk about chattels and the fact that a claim could follow the chattel just about anywhere, and that's not the way jurisdiction should work. There was a close call in the case of Worldwide Volkswagen that they had to make because it involved a dealership that was in New York that was challenging jurisdiction out in Oklahoma. But in Oklahoma, of course, there was the question, okay, well, the manufacturers are not bringing a jurisdictional challenge. It's only the dealer. And so the Worldwide Volkswagen case actually supports very strongly our position because the dealer really didn't have any connection to Oklahoma. The Bristol-Myers Squibb case is almost directly on point. In the Bristol-Myers Squibb case, the Plavix was the drug involved in those cases. It was a mass tort case, and there were multiple plaintiffs from various jurisdictions. And those plaintiffs never ingested Plavix in California. They weren't prescribed the medicine in California. They didn't live in California.
Yeah,
and
but the
ultimately they
closer
weren't injured.
analogy would be, yeah, they lived in or let's say the California pharmacy sent it across state lines to wherever it was that they lived. And that's the case that we really have. Like the first sale, there was a nexus to California. in some way in that Bristol-Myers Squibb case. That really wasn't answered in that case.
You know, and
Everything had happened out of state,
I think that...
including the defendant's activities, right?
You know, Justice Wendland, you put your finger on a problem. And I think that it was also identified in the concurring opinions in the Ford case. That saying this doesn't mean anything goes, or saying there are going to be limits doesn't necessarily provide a lot of guidance to the lower courts. That's been the problem since 1945, perhaps. And, you know, there was a move that was expressed in the concurring opinions to perhaps bring us all the way back to international shoe, or even before that to Pennoyer. But
I was hoping you were going to say Pennoyer.
But I found, by the way, obviously the courts are not going to go backwards on this, but you would expect some clarity, and maybe there's not enough clarity there, but the dicta, and it's dicta, but it's from the highest court in the nation, and it's in the past two cases, their most recent cases on jurisdiction. The dicta supports this position. As a matter of fact, in the Ford case, there is the quote. It's on page 15 of the slip opinion.
What's the other dicta? Because we've got Ford in our head. The other case,
The other cases I was talking about is Bristol-Myers Squibb.
yeah, and what is the dicta in Bristol-Myers Squibb? Because I remember that being hard to follow.
In Bristol-Myers, and it's discussed in the Ford case as well, Your Honor. I wouldn't say that it's dicta, actually, because
What's the language you want us to
the
look at?
language I wanted you to focus on is that they were not residents of California. They hadn't been prescribed Plavix in California. They didn't ingest Plavix in California. They hadn't sustained an injury in California. And that's identified in the Ford decision, and there's some discussion about that. But the focus I was trying to bring to the court just now about that page 15 comment is that they pose another hypothetical in the Ford case. Consider, and this is a direct quote, consider next to those. Now, the plaintiffs in that case were arguing that, and Ford was taking the position that it should be the point of sale, of course. But if it hadn't been an important concept that had to be considered by the court, or if it had been indelibly decided earlier, then the Supreme Court of the United States would not have taken on that case. It made the decision that they did. So they had to consider it, which is also, I would respectfully suggest, justification for why we made an argument up in New Hampshire that we're not making down here, because Ford intervened. But what happened was that those cars were not initially sold in the state of Montana or in the state of Minnesota, where those two respective plaintiffs came from. One of them was a passenger, was not a purchaser, but that's beside the point. But the court said, consider next to those the interests of the states of first sale, Washington and North Dakota, which Ford's proposed rule would make the most likely forums. For each of those states, the suit involves all out-of-state parties and out-of-state accident and out-of-state injuries. The suit's only connection with the state is that a former owner once, many years earlier, bought the car there. In other words, there is a less significant relationship among the defendant, the forum, and the litigation. Quoting Walden, which my brother mentioned earlier, Walden versus Fury. So by channeling these suits, and this is the key language, so by channeling these suits to Washington and North Dakota, Ford's regime would undermine rather than promote what the company calls the due process clause's jurisdiction allocating function. So essentially what Ford was arguing, in the eyes of the court at least, was considered by the court to be a proposition that would severely curtail the ability to decide a jurisdictional case without all of those paradigm facts in place. And ultimately, obviously, there is a discussion to be had about how many times in the Ford case, as I mentioned, it talks about residents of the state, in-form injuries, and the like. It's not as if they abandoned this notion that the accident, locus, the injury, and the residence of the plaintiffs should no longer be considered as facts to be determined. This case,
Okay, I'm gonna,
cut me off? I understand.
Thank you
and
very much.
Thank you for doing that so delicately, Your Honor.